This is a very important matter for our democracy. It's an important matter for all our citizens who are represented by members of parliament, whether those citizens are members of political parties, whether they voted or did not vote, whether they are even not of voting age. But thankfully, important as it is, this is a matter in which the issues are narrow and crisp, in my respectful submission. The only question which arises, and I was using this example when I was talking to the members of my team, to say, let's look at this as a multiple choice examination question. And the question then, bearing in mind that this is a matter that implicates the interpretation of primarily section 102.2 of the Constitution, as well as, to some extent, section 104, or rather Rule 104 of the Rules of the National Assembly. The multiple choice question, I posed it as follows. In respect of the secret ballot as a method of voting, the meaning of the expression, a vote, just those 5 letters, a vote, in section 102, is that a secret ballot is impliedly A, required, B, permitted, or C, prohibited. That is all that this matter is about. The parties will be seeking to various extents to convince you that the answer is A or it's B, as the applicants will do, or that it is C, as the respondents will do. The stances of the parties in general is that 5 of the parties, the political parties and CASAC, say it is A or B. In other words, it is either required or permitted. 2 of the amici, Shosholoza and ISS, say that it is B, but they are neutral as to whether it is also A. And 1, the UPM, says it is B, but not A. In other words, it's permitted, but it's not required. And of course, the respondents will seek to convince the court that it is excluded, prohibited, outlawed, whatever other synonym one can find. Now, the only problem we have is that it is not very clear, and I'm saying this with an eye to inviting my learned colleagues for the respondents. The ambit and scope of the defense or opposition is very difficult to work out. We tried to do an exercise on our side to work out who is opposing what. And it was quite a difficult exercise indeed. For example, the president says that he only opposes prayers 3 and 4. But at certain parts of the affidavit and the heads, and in fact, at the end of the affidavit, it is said that the whole application should be dismissed. Similarly, the speaker says that she has no problem with the secret ballot. And her only trouble is that she thinks that she does not have a discretion to order one. And so presumably once that problem is resolved, there would be no problem. But again, at various parts of the pleadings or the heads, it's widened to the extent that she says the entire application should be dismissed. And yet, there is a press statement which is in the papers that she issued and went so far as to say she doesn't know where this notion comes from that she's opposing this application. because she just wants clarity on this and the other. And I'll make a reference to that at a later stage. But be that as it may, we work on the basis that the matter is opposed in different parts by somebody in the respondent camp. What is very clear is that both respondents raise what I call the preliminary matters, which is exclusive jurisdiction or direct access. Or I forgot to mention, Chief Justice and Justices, that the issue of agency is no longer going to be raised. I have cleared that with my learned colleague, Mr. Semenya. So the preliminary issues would be jurisdiction and direct access. When it comes to remedy, it would seem, and of course our learned colleagues will enlighten us when they get their opportunity, it would seem that the President's position is that it would be inappropriate for him to enter the terrain of the Speaker, and therefore he does not express himself on the question of substitution or the review application. But when it comes to remedy, both parties raise the related question of separation of powers. That's the best we could do to work out who is opposing what, which relief. We are going to go mainly on what we call the primary argument, which is that the secret ballot is required or mandatory or compulsory, and we'll be using those synonyms interchangeably. And only in the alternative are we going to talk about whether it is permitted or allowed or discretionary or optional and so on. Now, in doing so, one of the approaches we're going to take is firstly to demonstrate that it cannot conceivably be prohibited. In other words, the only obstacle that the respondents can bring for our case to succeed would be to demonstrate that it is prohibited, and we will show that that is out of the question. Then the only question should be whether is it required or is it permitted. There will be an overlap in my argument, Chief Justice and Justices. When I deal with what I call the primary relief, I will concentrate on Section 102 itself, the interpretation, the preferred interpretation of Section 102 to support that argument. But those arguments will be of equal applicability to the alternative. So I will not repeat them when I deal with the alternative. And what I will then do, with the leave of the court, is when I do the alternative submission, then the main thrust will be the interpretation of Rule 104, bearing in mind that the constitutional submissions will be subsumed therein. But while I still have uninterrupted time, I want to say this. Contrary to all the commentators out there about what this matter is about, this matter is only about one thing and one thing only: the interpretation, what interpretation is to be given to the legal instruments in question. In other words, the Section 102 and the rule. And that is the most mundane and boring and everyday function of the court. When the parties have a dispute, whether it's about a section, whether it's about a contract, whether it's about property, that dispute gets brought to a court, because that is the only place where such a dispute can be finally resolved. And so I'm making this point for this reason. This case is not about the separation of powers, nor is it about the so-called encroachment of the court into anything, nor is it about the court likely to introduce anything. If our interpretation of Section 102 is correct, then that interpretation was always like that since 1996, when the Constitution came into being. Nobody's introducing. The court will simply be interpreting what is. And if we succeed on the basis that the secret ballot is required, compulsory, mandatory, and so on, then with the greatest respect, the issue of separation of powers does not come into it whatsoever. Because there the court will simply be saying, yes, Section 102 should be interpreted to say that it is compulsory. End of the story. If it is compulsory, then it's compulsory tomorrow, next week, next year, in 20 years' time, and so on. And that's the end of it. Only if the court, on the other hand, finds in our favor in respect of the second leg, in other words, that it is discretionary. And even then, when it comes to the question of remedy and the question of substitution in particular, clearly then issues of separation of powers become relevant in that narrow sense, because by definition, substitution means basically making the decision, for the court making the decision.
The 10 minutes is up.
Oh, well, Chief Justice, if you can permit me then to make the final point, which is this, that we will, in a nutshell, we will also ask for a special order against the president to pay costs personally and from his own pocket. And that I will address later. But in a nutshell, it is the complaint we raise is that the president was cited as a president of the country, and the ANC was cited as a party. The ANC chose not to get involved in this matter. But the president, using the state attorney or taxpayers' money, has sought to make submissions on behalf of the ANC, which is his private life or interest, so to speak. But we'll deal with that later. But finally, by way of introduction, I want to deal with what I'll call the atmospheric issues.
Are you still pleading for protection there, or may we?
Half a minute.
See, I offered you people 15 minutes. You said 10 minutes is enough.
Half a minute, Chief Justice. And it is simply to say this. If the Speaker is to be believed that she has no problem with the secret ballot for a minute, and that she seeks, and one has sympathy with that argument, because insofar as she says, look, there's a Kawama judgment, and maybe I think I'm constrained by it, rightly or wrongly, then one can understand that. She needs clarification. If that is so, then really what do we have here? We have the following situation. The only person in this country who is opposing the application that the motion of no confidence in the president of the country should be conducted by secret ballot is the president of the country. I will say something more about that later.
Mr. Mbofo, I'm sorry.
Yeah.
Shouldn't you start with what you described as preliminary issues? Why should we entertain this matter? What is the basis for us to hear it?
Yes. Thank you, Justice Jafta. We should. Well, the main thrust of these preliminary issues is the question of exclusive jurisdiction. Our submission is simply this. The entire source of I'm going to say that there are what I call sub-obligations and powers and so on. But the source of all this is the obligation on Parliament to hold the executive accountable. That obligation is by definition exclusive to Parliament, to state the obvious. But to travel from that obligation to the obligations that are pleaded here, we then say the following. In the discharge of that obligation, broadly speaking, in fact, let me put it like this. That obligation starts the minute that members of Parliament are sworn in. That obligation arises until the next election. And in the continuum of that obligation is the question of the motion of no confidence. It can manifest itself in various other ways, which I don't need to go into now. And the motion of no confidence itself is, if you like, with respect, can be viewed as an obligation, except that it's now almost an obligation on the president. The section says, to paraphrase, if a motion is passed, the president must resign. It could also have been worded the other way. The president must resign when a motion is passed. So it's an obligation on his part to do something.
Mr. Mpofu, I'm sorry, and it may well be that my brother still wants to put further questions to you. Just locate the obligation for us. In the clearest of terms, what is the obligation that rests on Parliament on which reliance is placed for this application? Just locate it for us.
Well, that obligation is to vote in a motion of no confidence. In other words, once a motion of no confidence has been placed, there are three obligations that arise. One is on the Speaker to schedule such a motion, and then the obligation on the members, Parliament, broadly speaking, the National Assembly, let's put it that way, to vote. And also an obligation on the National Assembly to debate the motion. Those are the threefold obligations. But narrowly...
No, you were going there. I just wanted a section and a subsection so that we know whatever argument flows from here hinges on this section of the Constitution.
Those obligations, Chief Justice, correct, arise from 102.2 itself, and also the ancillary obligations on the Speaker, which is really why we're here, arise also from the rules. So in other words, the Speaker has a duty, at the very least, to schedule, to allow for the debate or arrange for the debate, and also to arrange for the vote. And we locate the obligation here that in her obligation to arrange for the vote, she has also an obligation to, when asked, as she is asked now, to choose the method of voting, to do so. She has abdicated, to put it bluntly, that the discharge of that obligation, and that is why we're here.
But the Speaker is not Parliament, is she?
Well, she is and she isn't. as she has accepted that she has been cited as the representative of Parliament. So she's the embodiment of Parliament. When somebody is litigating against Parliament, we cite the Speaker in that fashion.
Doesn't the Constitution define what Parliament is, Mr. Mpofu?
Yeah, no, of course, the Constitution does, but what I'm saying, Justice Shafter, is that the Speaker must be seen in her multiple roles. She says herself in her answering affidavit, I'm cited here as the Speaker, I'm also cited as a representative of the National Assembly per se.
But should we go by that? Shouldn't we go by what the Constitution says, tells us what Parliament is, when we are searching for determining whether Parliament has failed to fulfill one of its obligations?
Yeah, yes, of course, it is like that, Justice Shafter, but just as when we say the Department of Home Affairs has failed to do something, that Department of Home Affairs is just an inanimate thing. The person who has really failed is either the DG or the minister, depending on the matter. But you can't say the Department of Home Affairs. There's no such thing as the Department of Home Affairs. It's just a fiction. So the real department is represented by an official who is designated constitutionally to represent that institution. And that's all we're saying. We're saying the Speaker then comes in two guises, as the Speaker, but also as the representative, the constitutional representative of Parliament.
But